Good afternoon. Please turn and introduce yourself to the members of the jury.
My name's Elmer. I'm Elmo Fudd's brother.
Now, Mr. Fudd, where are you from?
I'm from Plant City.
Were you at Stetson University College of Law on May 25th, 2012?
Yes.
Objection, Your Honor. Counselor is leading the witness.
Sustained.
Where were you on May 25th, 2012?
I was at the Stetson School of Law.
Was it raining that day?
No.
Objection, Your Honor. Counselor is leading the witness.
Sustained.
Was it sunny out that day?
Yes.
Objection, Your Honor. Counselor is again leading the witness.
Sustained.
Your Honor, may we approach?
You may.
These questions don't qualify as leading questions under the Federal Rules of Evidence because they're not suggesting an answer to the witness.
Counsel, your questions call for yes or no answers. Those are leading questions. Ask questions that don't call for the witness to simply say yes or no.
Yes, Your Honor. Mr. Fudd, what, if any, conversations did you have that day?
I was talking to Daryl. He was with me.
And what did you say to Daryl?
Objection, Your Honor. Hearsay.
Overruled.
Yes, Your Honor, but counsel's asking the witness to make statements made outside of court for the truth of the matter asserted.
I understand that, but the witness is right here on the witness stand. Look, I just got back from a conference in California with all of their trial judges. That's the way the hearsay rule works. The witness is here. The witness can testify as to what the witness said, not what Daryl said. Sit down, counsel.
Good afternoon. Please turn and introduce yourself to the members of the jury.
My name's Elmer. I'm Elmo Fudd's brother.
Now, Mr. Fudd, where are you from?
I'm from Plant City.
Were you at Stetson University College of Law on May 25th, 2012?
Yes.
Objection, Your Honor. Counselor is leading the witness.
Leading? Overruled.
Was it raining that day?
No.
Objection, Your Honor. Counselor is leading the witness.
Overruled, counsel. You may continue.
Was it sunny out that day?
Yes.
Objection, Your Honor. Counselor is again leading the witness.
Overruled.
Your Honor, may I approach the bench?
Yes, you may.
Professor Deise, Judge Stribe just taught me in class that whenever we're asking witnesses questions, that when they can only answer with yes or no, that we're leading the witness.
Well, Nikki, you're about to learn a very valuable lesson as a law student, and that is that often judges don't know what the hell they're talking about when it comes to understanding the federal rules of evidence. And this is a classic example, right? To make the argument that you make that these statements, simply because they can be answered yes or no, that's leading, is absurd. And I suggest that, and I will suggest to Judge Stribe that he sort of revisit the rules and also revisit some of the cases to inform him better about what in the hell constitutes leading versus non-leading questions. You understand?
Yeah, just don't kill the messenger.
Mr. Fudd, what, if any, conversations did you have that day?
I was talking to Daryl. He was with me.
And what did you say to Daryl?
Objection, Your Honor. Hearsay.
Sustained.
Your Honor, may we approach?
We may.
I'm in class with Nikki too, and Judge Stribe told us that if we're looking at what the witness themselves have said, that even if it was said outside of the court of law, that it's okay and it's not hearsay. I'm just confused.
Counsel, you were a student in my basic evidence class, right?
Yes.
You understand the rules of evidence, don't you?
Yes.
You understand specifically what Federal Rule of Evidence 801 and 802?
I do, but
specify?
the judge told me to do it this way.
Okay. Once again, as I said to opposing counsel, it's another valuable lesson for you today, because this is another clear situation in which Judge Stribe was completely wrong. He needs to revisit, and I suggest that you might also, in an abundance of caution, revisit these rules of evidence. The definition is very clear, and as lawyers, we need to commit certain definitions to memory, right? Evidence, right? Statements made by the declarant, other than while testifying in court at trial, offered for the purpose of proving the truth of the matter asserted, right? That's hearsay. This was a statement made by the declarant, right? Not in court today, but on an earlier occasion, May 25th. How in the world is that not hearsay? Offered for the truth of proving the matter asserted that it was indeed a sunny, bright day. Counsel, how is that not hearsay?
Oh, I guess it is, but I'm just telling you what I've been taught by the judge.
I understand, and this is the problem with having to rely on some adjunct faculty or volunteer faculty. Again, I love Judge Schreiber as a person. He's a friend of mine. I've known him for many, many years. But the reality is he's giving the wrong message, and I guess, he is doing this for free. So we're grateful for that, but I guess we're getting what we pay for in this instance, right? That's wrong. It is just blatantly wrong. And I'm going to have a chat with him about that. So, Laura, how are you going to deal with Judge Schreiber the next time he gives you advice that's inconsistent with what you know the law to be? How are you going to deal with him at that point?
Well, the next time it happens while I'm in the classroom, I'll follow by what he is. I guess the rules are subject to interpretation, but afterwards I'll come by your office and let you know so that maybe somebody can let him know that this isn't how we do things here.
Mike, I got to talk to you about something. You and I have been buddies for a long time, and I love you, and you've done so much for this law school. I've learned so much from you. What you do for us at the law school is really a labor of love because you're really not compensated for it. You're a distinguished member of the bench, and I could go on and on and on. And that's why it makes it difficult for me to have to sort of discuss this with you. We had a situation in which two of our students, Nikki and Laura, did a demonstration before you in which they did a direct examination, and there were two specific objections that were made. One had to deal with leading questions, at which point you have sustained the objection because you said it was your understanding that any question that called for a yes or no answer was leading, and so that was your understanding of, I guess, Rule 613. 611, but you sustained the objection. And another time, Laura asked the question of the witness, which caused the witness to discuss an out-of-court incident in which the witness had a conversation with his buddy, and that conversation was being offered to prove the truth of the matter asserted. That is, that it was a nice day. You ruled that that was not hearsay because the witness was on the stand and presumably now is under oath, now is subject to cross-examination, now is able to be perceived by the jurors, and those kind of things. Those factors of reliability that we look for. But the problem is, and I know that the rule, the federal rule of evidence that these students are taught, on which they'll be tested on the bar exam, and more important, which they'll be using in practice, doesn't make that distinction. In other words, the rule is very, very clear that any statement made by the declarant, other than while testifying in court, offered to prove the truth of the matter asserted, is hearsay, right? There's no if and or buts about that. And so Lori and Nikki came to me, and they were a little bit upset, but they were really, really confused because they're saying, Professor Deise, we're getting mixed messages. We've got Judge Schreiber, who's this very distinguished judge. We've got you, and I've got grades to think about, and I've got my relationship with Judge Schreiber to think about. We're between a rock and a hard place. And so they came to me, and we talked about what they can do as lawyers to sort of deal with judges who rule in a certain way, and it may be adverse to actually what the law requires. We talked about what they can do, but they also suggested that maybe it would be helpful if I were to have this conversation with you to sort of talk to you about the importance of sending the same message to the students. Now, one of the things that I take responsibility for is I think I should have done a better job of making it clear before we started teaching that there was consistency, that the students were being sent a consistent message. And to the extent that there were different interpretations of a rule, and that matters, then I think, I should have, and again, I take responsibility, I should have had that discussion with you then. And so, in part, I want to apologize to you for putting you in this position in the first place, because I think, had I been more thoughtful, it could have been avoided altogether. So that's kind of what I needed to say to you.
Jerry, I understand. I can be a stickler about leading questions. I would have preferred the students to ask what the weather was like, but I understand what you're saying. The hearsay thing, well, I know a lot of the judges in California, and some of my brethren feel that if the witness is on the stand, we shouldn't be so strictly enforcing the hearsay rule, but you're right, that's the literal rule. And look, I get your point. These aren't experienced lawyers. They're law students, so I'm going to give them a little more rope than I would a lawyer in my courtroom, and we should be consistent. And I appreciate you bringing this to my attention. I'll